Welcome to First Year Criminal Law. This is just going to be a bit of an overview of some of the topics that we're going to cover this semester, just so you get introduced to them before we deal with them in detail in the classroom. And the focus this semester is going to be on how the Crown proves a criminal charge against an accused person. And the reason we start at this place in our analysis is because of the presumption of innocence, perhaps one of the most fundamental and important concepts we will look at throughout the year. And it's this idea that every person, and it doesn't matter if that person is reported in the press to have confessed and they found DNA at the scene and 25 witnesses come forward, when they come into that courtroom, they are presumed innocent. And it doesn't matter, again, if they're shackled to the floor and it's a high security courtroom and they're sitting in the prisoner's box, the judge will tell the jury that person is innocent. And they will remain innocent until the Crown has taken all the steps it's required to do to prove the person guilty. And the first step we're going to look at this semester has really nothing to do with the particular evidence in a trial. It's putting the law on trial. Every person is prosecuted under a criminal offense, and in our system, as we'll get into, those are written out in the criminal code. And the first thing you can do as defense counsel for an accused person is put that law on trial. We have certain requirements that a criminal law needs to meet, and that makes some sense. Think about it. It's the heaviest form of sanction you can use in a society to deter certain behavior. A criminal law that has with it a strong likelihood of taking away a person's liberty and has reputational effects that could affect the person for the rest of their life. In that context, we have put limits on the type of offenses that can be created by Parliament. And we're going to look at some cases where the accused has attacked the validity of the law and has been able to strike down the law. And once you strike down the law and the law is no longer valid, there can be no criminal prosecution. So that will be an essential first step we'll look at. Is the law valid? The next step we will look at is the Crown proving its specific case against an accused. And one thing we're going to spend a fair bit of time doing is breaking down a crime into its essential elements. Okay, and most crimes will have 2, 3, 4, 5 essential elements. And the reason we break them down into individual elements is because the Crown has to prove each of them in order to prove the offense. If the Crown proves 5 out of 6 things or 3 out of 4 things that they have to prove, the case will not be proven and the accused will be acquitted of that offense. Now, we'll look at each individual offense, but there are generally 3 areas that those essential elements will fall into. Okay, and let's take a very simple case. A person is alleged to have stolen another student's laptop computer. Okay, the first essential element that will be present for every offense is proving identity. Okay, proving that the person sitting in the prisoner's box is the person who is alleged to have been engaged in the criminal conduct. Okay, if the person, as the students were leaving the classroom, the allegation is a student picked up another person's laptop and left the room with it. Okay, you would have to prove that the accused, the student who is the accused, was present in that classroom and was there that day near the computer when the theft allegedly occurred. Okay, that's always a fundamental starting point for the Crown proving its case. Can they prove that the identity of the person in the courtroom is the same identity as the person alleged to have engaged in the criminal conduct? The next step the Crown must generally prove is something we call the Actus Reyes of the offense. Most offenses engage certain conduct that an accused has done that we've deemed as a society to be criminal, often because it creates some harm or risk of harm to people or property. Assaultive conduct, theft, fraud, mischief, something that causes some form of harm, okay, we have made that conduct a criminal offense, and the Crown has to prove that that conduct occurred. Remember, you've now got the identity of the offender. You have to prove they did something. Okay? And for something like theft, it would be the act of taking someone else's property and leaving the room with it. Okay? For something like assault, it would be applying force to a person. For a crime like murder, it would be assaulting somebody and causing their death. And the key is there, we're trying to define certain conduct that had to be committed and see if the accused indeed did commit that conduct. So that's the conduct part of an offense that we'll spend a lot of time with. Sometimes it's a very simple form of conduct the Crown has to prove. Okay, for an assault provision, again, you just applied force to somebody. Again, sometimes the criminal offense has more complex conduct because what you did needed to cause another event, or you needed to engage in that conduct in certain circumstances, such as carrying out a certain act in a public place. Okay, but it's all grouped under the idea that the accused engaged in certain misconduct and the Crown proves the person did carry out that act that the criminal code says you can't. Okay, but almost every crime has a step beyond that. Now, what do we have so far? We've identified the offender. Okay, they were the person in the classroom. They were sitting beside the person whose laptop was stolen. And so that's identity. Okay, and then there were some witnesses coming forward saying they picked up the laptop, they looked around a bit, and then they left the room with it. Okay, we've now proven identity, and we've now proven they engaged in the conduct of theft, taking someone else's property and taking possession of it. Okay, but there's a third general area that almost every criminal offense has to be proven, and that's that you engaged in that criminal conduct with some form of moral culpability. That you engaged in that conduct with some level of fault. And when we think about, again, criminal conduct, subject to taking away your liberty, affecting your reputation, potentially for life, okay, I think in most circumstances we're not going to want to criminalize someone making a mistake. We're going to want to criminalize someone who was aware that they were engaging in that conduct. So we're going to see another important area that the Crown has to prove is that the accused carried out the offense with a certain mindset that creates fault. And one of the easiest examples in theft is knowing that it was not your property. Okay, in order to prove the offense of theft, it's not enough that you take the computer and take it into your possession. You need to be aware that it does not belong to you. An accused person who thinks it was their computer, that person is not guilty of theft. The Crown has proved certain elements of the crime. They've proved identity. They've proved that the accused engaged in the Actus Reyes of taking the computer, but the Crown cannot prove that the person had the guilty mindset, which in that case is knowledge that they were taking the computer. Okay, another example that we'll look at later in the semester is murder. Okay, again, murder, if someone's shot in a parking lot and the Crown alleges it's murder, you have to prove identity, prove that the accused was the person in the parking lot holding the gun. Secondly, you have to prove the Actus Reus of the offense, that they did pull the trigger of the gun that caused the wound to the victim and that wound caused the person to die. Okay, so that particular Actus Reus is a little more complex. You do the assaultive activity of firing the gun, but then you have to find the firing of the gun caused the person to die. But then you have to prove the fault element, and the fault element is an intent to kill, that the accused had to be subjectively aware that their actions were going to cause the death. And that's what we call the mens rea of the offense. Okay, the fault standard, the mindset that the accused needs to have. And one interesting thing we're going to look at through the semester is whether or not the accused person always has to have a subjective awareness that they are engaging in the prohibited conduct. We'll see for many offenses that's true. Again, assault, you need to apply force and know you are applying force to the person. For theft, you need to take the item and be subjectively aware that you are taking someone else's property. But one thing we'll look at a little bit later in the semester is whether someone can be convicted of a criminal offense based on negligence. And for negligence is a concept of the accused may not have been subjectively aware that they were doing the prohibited conduct, but they should have been aware that a reasonable person would have realized that they were making the mistake that the accused made. Okay, so an example would be someone goes and takes a laptop that is not there when they leave the classroom, and their subjective mindset they are able to establish to the court is that they thought it was theirs. But what if that laptop was a much different size and color to it? And almost every reasonable person would have realized that they were not taking their own computer because it was an utterly different size and color. We'll look at this semester whether or not you can convict somebody of some offenses, not because they knew they were engaging in the prohibited conduct, but they should have known. They were reckless. They were negligent in not realizing what they were doing, and convict them of that offense. So those are the main things we're going to be looking at this semester. Proving the case. First dealing with, is the law valid? Okay, and if the law is valid, moving towards the essential elements the Crown has to prove, and we'll work these out in class. They're often quite detailed, but they fall into these three main categories. Proving identity, proving the Actus Reyes, that they engaged in the conduct the law says you can't engage in, and thirdly, proving the mens rea, proving that they engaged in that prohibited conduct, often with subjective knowledge. They actually knew that they were engaging in the prohibited conduct, or in some cases that they should have been aware that they were engaging in the prohibited conduct. Thank you.